Hey everybody, welcome back to the channel today. We're going to continue and talk about this government claim form. I just made a video about it. We did a comment section video. If you haven't seen that yet, once this video is over, go ahead and click the link right there at the top right. Give that one a view. But I wanted to expand upon that, and to help me do it, we have brought in another wonderful attorney from Michelle and Associates. Tiffany, thank you for taking the time with us today.
Yeah, I'm glad to be here.
Well, thank you again. And so I just wanted to expand on this. There are a lot of questions rising. Really, what is next? So we had this government claim form after we saw the class action lawsuit on the DOJ data leak. The time frame for you to file that claim form has now come and gone. We are even seeing a couple people getting rejection letters from their government claim forms. What exactly is it that we need to prepare for next, and what is it that we need to look for?
Sure. Well, for months, CRPA has told people get your government claim form in. And the reason for that was to be able to preserve your right to sue later on. Even if you didn't think you were going to sue, you always want to try to preserve that right because you never know what's coming. So everyone who filed their government claim form by the end of December, which I think was December 20th, they have 45 days to wait from the filing of that claim form to see if the government does one of two things. They can either dismiss it and say, we're not going to accept that claim within 45 days, and you should get a written letter from the government, from the state of California, saying they're not going to accept that claim, or they can ignore it. And those two things have very different ramifications. If you receive a letter after the 45 days that says your claim is not being granted, which is typical, the government typically denies the claims, then you have 6 months to file a lawsuit if you want to file a lawsuit. If they just ignore the claim form and they never respond to you, then after that 45 days, it extends that time period to file a lawsuit up to 2 years. So we think that they're going to try to get as many letters out in denial as possible because they don't want to have that 2-year extension where people can file suit against the government for the leak of their private information. So that's what happens pretty immediately. And then if you get a letter, there are some other options that you can do as well. If you didn't file a claim form, that door is pretty much closed at this point. There's not a lot of other options that you have if you did not file a claim form and preserve that right. But if you did file a claim form, you can do several things. You can file in small claims court, which I think CRPA has a landing page that has a lot of information about this leak from the DOJ, and there's a section on there about small claims and what to do and how to do that. And I'm sure that that's going to be expanded upon as we move forward. You can get an attorney and you can file a claim in the Superior Court. And CRPA also is filing a complaint for a plaintiff that we have a sample complaint form on that landing page on the website, and people can take that information and they're going to be able to use that throughout their complaint process. So if they want to get an attorney and they want to file, hopefully that will cut down on a lot of the work that goes into that, because we'll already have a complaint that is filed and you can use those documents throughout your legal journey if you want to do that. And then the third thing is there may be a statutory claim under the California Privacy Act that someone can file. It's not very much money. It's around $1,500 that somebody could get, but there are some problems with that. You still have to prove damages, and you have to be able to prove that the act was intentional. And we know the DOJ has already come out with their report saying it was not intentional. So there'll be some discovery there, just like if you filed in the regular courts. So either of those options are available to you after the 45 days. It's just you have to decide, which is best for you.
Okay, so what you're saying is, There are three options. Two options look better than the third. You can hire an attorney and file at the Superior Court, or you can file at small claims court. Obviously, there's a difference there in the amount of money you can get if you end up winning. But where you're telling people to look is at the test case. So how far along is the test case exactly, and where has the test case been filed?
Sure. So the test case is getting ready to be filed. We have the draft complaint up on the CRPA website for people to look at under it's one of the sliders on the main homepage, and I'm sure you'll put a link up there for it. But it's on that page to sample. That plaintiff just got back their letter denying their government claim form. So now that will be filed. So it's just at the beginning stages. People can follow along with that case and see how it's going. But, just like any court case, it takes a while to get things done properly and go through the process. So you should start seeing more come out on that. And then also on the small claims portion of that website as well. And I just want to mention too, a lot of people keep bringing up the class action. And what about the class action? What happened to that? There is no class action being filed right now that we know of. There was one that was filed early on, like as soon as the leak happened, but there's a lot that goes into a class action. And if all of the damages from all of the people in the class are not similar in nature, then it's really hard for a class action to move forward. And that's what the court found, was that they weren't similar enough. So there is no class action. We are in a world now where you have to take action on your own, either through small claims or an individual attorney.
Okay, and I mean, as I'm looking through our comment sections and some of the emails that I've been getting, I've been hearing a lot of people say, well, I don't necessarily have excess money to hire an attorney and file this at the Superior Court. If that is the case, we might be looking at a lot of these getting filed in small claims court. Can you just go over, just to double check me here, no attorney required for small claims court, and it's a small fee, right?
It's a small fee to file. You do not have to have an attorney. You can have an attorney, but it's the purpose of a small claims court is for you to bring a claim that maybe isn't as excuse me, as involved as other court cases. So if you just want to try to get some damages out of it and you don't want to hire an attorney, that's the route to go. There may be some attorneys out there who will do it on a contingency basis. I don't know. But even so, they should still probably be able to get maybe some attorney's fees at the end if they win the case for you. So there's a lot of options that you can talk with your attorney about as far as how do you pay for something like this. And that would just be between you and your attorney.
Well, where I'm thinking is, we've been saying for the longest time, part of the anti-2A strategy has been to bleed us dry. They force as much legislation down our throat as possible so that we then have to spend time and money fighting this stuff in court. I guess the roles are sort of reversed here. If we're looking at thousands or tens of thousands of small claims courts having to deal with this issue, do we see a similar effect, but having the roles reversed? How substantial could this potentially be?
It could be substantial. There were millions of people that were on those lists that their personal information was released. So if everybody filed in small claims court, yes, it could be very impactful. Not only that, it would just make great news coverage of how badly the DOJ screwed this up. And so I think what we're hoping is that a lot of these court cases that are filed, because we anticipate there will be numerous ones filed, that will bring to light some of the evidence of whether or not this was truly an accident or whether it was intentional in some way. And there's different levels of intention. There's kind of a general sense of intention where they generally meant to put the information out on the internet, but maybe they didn't mean to expose as much information as they did, or there's specific intent is what it's called, specific intent, where someone meant to push the button and release the information. And so those are the types of things that courts are going to consider. And so the more lawsuits that are out there, the more information will come to light, and we'll learn more about it, about what actually happened.
I guess my last question is especially in something like small claims court, when it comes to lawsuits that we've filed, or, we look at the New York Rifle and Pistol Association recently, or just laws in general being ruled on in court, precedent ends up being a big thing. For something like this, is precedent a thing at all, or are these cases done on an individual basis? For example, if somebody does prove in their individual case intent on behalf of the government, does that bleed over into any other cases, or are they all done individually?
Well, it depends on where they are in the process, and what court rules that. But absolutely, you can use any kind of information from another court and their ruling. It may not be binding precedent. It might just be something that you use to say, look what the other court found, and it's not binding on your court. But yes, you can use the rulings of other courts in your cases to to help further your arguments. Absolutely.
Awesome. Well, hey, we're definitely going to continue keeping an eye on this. Like she said, go to crpa.org to track this, just like we're going to be tracking it. Tiffany, thank you so much for taking the time today. I really appreciate it.
Of course.
So as promised in our prior video, we are going to try and address at least one comment from the past video. This one comes to us from @OldVeteran. Why isn't the Supreme Court's decision final when they make a decision? So I guess there are a couple of different ways to look at this. The overall answer, though, is it is final. We have the Heller decision that secured the individual right in the home to protect yourself with a firearm. We now have the Bruen decision that secures, our ability in the court to hold these laws up to the scrutiny of history, text, and tradition. But there are a couple of ways to look at it. First of all, I've said this before, American ingenuity is pretty amazing. When the California legislature starts defining centerfire rifles as assault weapons, our manufacturers get around that by they first created the bullet button, and then the lawmakers decided to throw that into the definition. So then we made the AR maglock, but these are ultimately ways that we are getting around the law while, not being able to not having to classify your rifle as an assault weapon, even though they create these ridiculous definitions. And the fact is you can kind of do the same thing with the law. So when you're creating a law, you can make tweaks that, maybe, satisfy something that you see in a prior court case and a decision there, but still be able to infringe on Second Amendment rights. I think the other way to look at it, or at least another path that you can look at it, is there are plenty of elected officials and legislators around the country that care about the people that they represent. They care about their constitutional rights, but that doesn't always apply to every legislator. And I think that we have some activist legislators that care less about the citizens' constitutional rights, especially when you come to the Second Amendment and just people flat out not believing that it should be a constitutional right, where they prioritize their political agenda over that. But that is the checks and balance system. We have the legislature that creates laws, and the checks and balances we have on that legislature is the courts. And at the end of the day, that court system is going to abide by Bruen's ruling and view that law under history, text, and tradition. So it might be frustrating, and it might not always seem like the Supreme Court's decision is final when they make it, but at the end of the day, we are seeing these lawsuits viewed through history, text, and tradition now, and that certainly makes them final. Again, guys, we're on the road to 10,000 subscribers, and you can help us get there. Please be sure and like, share, and subscribe to these videos. It really helps with the algorithm, really helps get the message out there. Thanks again, and we'll see you on the next one.